comprehend to the charges she is facing. Counsel further argued on the limitation of rights and fundamental freedoms under Article 24 of the Constitution, submitting that rights of fundamental freedom cannot be limited only to the extent that the limitation is reasonable, justifiable in an open, democratic, and civilized society. Counsel also made reference to Article 19, 20, and 27 of the Constitution. On this part, that Kiragu extensively submitted on the composite of the offense that the suspect is facing, basically urging that the three ingredients to the offense has not been disclosed sufficiently. Concomitantly offending Article 52B of the Constitution. The learned counsel, Mr. Wambuku Wanjoy, iterated that the charges were not warranted since no clear offensive conduct had been identified, with the charge sheet being broad, vague, and ambiguous. He adjured that Section 94 of the Penal Code criminalizes conduct and not political opinion or opinions, and with no nexus between the words alleged uttered with the breach of peace. Conversely, on behalf of the state, Mr. Whitty vehemently opposed and backed the application. He unerringly submitted that jurisdiction is everything, reverberating the old aphorism that a court of law down its tools in respect to or matter before it. He reverberated the old aphorism that a court of law down its tools in respect of the matter before it the moment it holds the opinion that is without jurisdiction. On the jurisdictional question of Section 881 of the Magistrates Court Act, learned counsel argued that under Section 828 of the said Act, this court's jurisdiction is stemmed and hamstrung to rights under Article 25A and B of the Constitution. Corollary, excluding Article 10, 19, 20, 27, and 33 of the Constitution. He further argued that Section 94(1) of the Penal Code is in force and applicable in collocation to Section 7 of the 6th Schedule of the Constitution. He exhorted that, pursuant to the Article 2, Sub-Article 2 of the Constitution, this court has no powers to legislate. Learned counsel further, Mr. Whitty, submitted that the relevant law governing the framing of charge sheets are found under Section 89, 134, 135, 136, and 137 of the Criminal Procedure Code. He argued that the charge sheet presented encapsulated the statement of offense and the particulars sufficient to be understood by the suspect. He enjoined that at this stage there is no need to prove any ingredient, each of the ingredients, since the court will be falling into a danger of conducting a mini trial. He beseeched that the ingredients ought to be established during the main trial. So he relied on two authorities, the Kuldeep Madan and another versus Director of Public Prosecution, as well as Hussein Khalid and 16 others. So decision from the foregoing, two issues arises for determination, namely, jurisdiction to enforce the Bill of Rights by the magistrate courts. Secondly, the competence of the charge sheet. So on the question of jurisdiction, I'll start off with the Supreme Court case, Supreme Court of Kenya in application number 2 of 2011, involving Samuel Kamau Macharia versus KCB and others, 2012 EKLR, which the court held, and a court's jurisdiction flows from either the Constitution or legislation or both. Thus, a court can only exercise jurisdiction as conferred by the Constitution or other written law. It cannot arrogate to itself jurisdiction exceeding that which is conferred upon it by law. The court must operate within the constitutional limits. It cannot expand jurisdiction through judicial craft or innovation. End of quote. I'll also cite the famous case of owners of motor vessel, EMS versus Perfect Oil Kenya Limited, 1989, EKLR, where I'm sure all of us are familiar with this authority, so I'm not to read it. So as aptly stated by both parties, the jurisdiction of the Magistrate Court in dealing with the enforcement of the Bill of Rights has since been addressed by Section 8 of the Magistrate Court Act. The parameters, despite being clearly stated under Section 8, Section 2 of the Act, has also found fortification in the Supreme Court a decision of Hussein Halid, which I've quoted before, during above, where the apex court, whose decision is binding before this court, enunciated thus, and I quote, Parliament has granted to the Magistrate Courts powers to consider applications on alleged violation of the Bill of Rights, but has limited the power to only two rights under Article 25A and B. And that, according to the apex court, is that one is for the freedom from torture, cruel, inhuman, or degrading treatment or punishment, and also the freedom from slavery or servitude. I proceed to quote the apex court. This limitation is constitutional, as Parliament does not bar a person from bringing a case alleging violation of his rights, but only limits the forum where that cause can be done. They have cited this was captured by the High Court of Australia. I will not go into those. You can have it once you have this ruling. So I'll share with you so you have a look at it. So, learn from the foregoing, it is crystal clear and need not be belabored further that this court can only enforce rights that fall within Article 25A and 25 subsection B, paragraph 3 of the Constitution. Therefore, on the elemental question of jurisdiction, I will down by 2. So I go to the second question for determination, and that is of the competence of the charge sheet. So the first port of call is on the mandate of the DPP. The office of the DPP is an independent constitutional office which is not subject to the control, direction, and influence of any other person. Under Article 157, Sub-Article 10, and Section 6 of the Act, the DPP shall not require the consent of any person or authority for the commencement of criminal proceedings, and the exercise of its powers or function shall only be under the direction or control, or shall not be under the direction or control of any other person or authority. The independence of that office is, however, not absolute. Article 157, Sub-Article 11 requires that the holder of such office to have regard to public interest, the interest of the administration of justice, and the need to prevent and avoid abuse of the legal process in exercising the powers conferred by the Constitution and the Act. So, based on the foregoing, it follows that the DPP can present charges within the confines of the law. The question for settlement now is whether, and which is paramount, is whether the charge sheet against the suspect is competent. So there are a plethora of authorities on question of the competence of framing of charge sheet. So I'll not go into that. I'll go into Section 134 of the Criminal Procedure Code that states, and I quote, every charge or information shall contain and shall be sufficient if it contains a statement of the specific offense or offenses with which the accused person is charged, together with such particulars as may be necessary for giving reasonable information as to the nature of the offense. End of quote. I'm not going to read Section 176. I've elaborated the provision of that Section 176, 137. So courts, as I've stated, has also considered what is essential in framing of a charge. In the often cited case, in the realm of framing of charges, the case of Sigilani versus Republic 2004, 2 KLR 480, I'll not cite that. What the court stated. So further, the Court of Appeal in Nyamai Musyoka versus Republic 2014 also expressed itself on the test whether charge sheet is fatally defective or incompetent. I will not cite it. So indubitably, therefore, a charge must